Good day, Crime Talk aficionados. We have a great show for you today. First, the murder trial of the CashApp founder. Well, they've reached a verdict. Deker Chauvin wants a new trial, and a federal judge is giving him an opportunity to make a case. Luigi Mangione is back in court. Oh, yeah, and he got indicted. The Gilgo Beach murder suspect just got charged for alleged murder number 7. An armed career criminal finds his way back to prison after compassionate release. A Florida man gets the ultimate punishment. A Denver judge gets a censure for being drunk on the job. We have this day in legal history and our dumb criminal of the day. These guys just couldn't do anything correct. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Please go to CrimeTalkSearch.com, sign up for that background subscription service today. When you have that subscription, you can do as many background searches on anybody here in the United States that you desire. And let's face it, if somebody new is coming into your life, you want to check them out. You're going to be able to get information on, well, phone numbers, emails, social media presence. Why do they have 10 different emails? Well, maybe it's for all those sites that they're signing up for that they don't want you to know about. May want to check that out. You're going to find out if they own property. Do they have judgments against them? Do they have a criminal history? Are they on one of those public registries, where you have to register every quarter or every year? Go to CrimeTalkSearch.com and check it out. You're going to be happy that you did. All right, it is Tuesday night, so what does that mean? That means we're going to go live tonight, 6 p.m. Mountain Time. We're going to do our regular Tuesday night live program, and then immediately following that, we will do our Patreon show. So if you would like to join us, please do. We will be here. We'd love to see you. Love to take your comments. We'll be talking about Luigi Mangione and everything else going on in the news related to true crime. All right, let's go ahead and open the record for December 17th, 2024. First, the CashApp murder trial has come to an end. That's right. The tech consultant Nima Momeni was found guilty on Tuesday of stabbing CashApp founder Bob Lee to death during a drug-fueled dispute over Momeni's sister. So after 7 full days of deliberation, the 12-member jury convicted Momeni of second-degree murder. He now faces 15 years to life in prison. Now, the jury did not find him guilty of the most serious charge of first-degree murder, which the members had been instructed could only apply if they were convinced that Momeni killed Lee willfully, deliberately, and with premeditation. Now, Mr. Lee was stabbed through the heart under San Francisco's Bay Bridge on April 4th of 2023. He called 911 and begged for help as he wandered the streets, leaving a trail of blood behind him as he walked aimlessly looking for help. He told the dispatcher that someone had stabbed him but did not name his killer in his dying breaths. Well, needless to say, the police soon zeroed in on Momeni, who had been spotted on surveillance video with Lee just 30 minutes before the stabbing. Now, prosecutors had alleged that Momeni was getting revenge on behalf of his younger sister, Kazar, who had been having an affair with Lee. Now, the sister testified in court that Lee's drug dealer sexually assaulted her on the day before the homicide, and prosecutors told the jury that Momeni described himself as an overprotective big brother and that he blamed Lee for the assault. Now, the prosecution argued to jurors that Momeni lured Lee to the secluded place and then viciously stabbed him with a kitchen knife he had taken from his sister's apartment. Now, Lee was found with ketamine and other drugs in his system at the time of his death and had reportedly been drinking with Momeni and his sister the day before the murder. Now, during the 6-week trial, Momeni took the stand on his own behalf, testifying that he acted in self-defense after Lee got aggressive with him. He said, quote, "I made a bad joke," he told the jurors, "and if it was my last night in town, I'd go hang out with my family instead of effing around in strip clubs. I set him off. He just blew up in front of me. He went from 0 to 100. Now, Momeni then testified that Lee pulled a knife on him and he simply fought back. So there you go, ladies and gentlemen. Second-degree murder. not after deliberation, although when you lure somebody there, you kind of wonder why. But hey, maybe that's why it took them so long to get there. But obviously, they did not believe the defendant in this particular case because he testified to self-defense. They rejected that. Next on the docket, Deker Chauvin wants a new trial, and a judge is giving him the opportunity to make a case. So a federal judge has granted permission to the lawyers for Deker Chauvin to have samples from George Floyd examined as part of the former Minneapolis police officer's effort to challenge his conviction on federal civil rights charges stemming from Floyd's death back in 2020. So U.S. District Court Judge Paul Magnuson agreed in an order Monday to let the defense examine Floyd's heart tissue and fluid samples to test a theory that Floyd died of a heart condition aggravated by a rare tumor, not as prosecutors contended from asphyxiation caused by the officer pressing his knee on the neck of Mr. Floyd for 9.5 minutes, despite Floyd's dying cries of "I can't breathe." So as you may recall, Chauvin was convicted in state court on murder charges in 2021 and pled guilty later that year in federal court to violating Floyd's civil rights. Well, his federal public defender for his appeal attempt, Robert Myers, has argued in his request that Chauvin's original attorney, a guy by the name of Eric Nelson, failed to inform his client that an outside pathologist not directly involved in the case, a Dr. William Schatzel of Topeka, Kansas, had contacted Nelson before Chauvin entering his plea and offered an unsolicited theory that Chauvin did not cause Floyd's death. Chauvin claims that amounted to ineffective assistance to counsel and is seeking a new trial, saying he would not have pled guilty if he had known about the pathologist. However, the prosecutors have argued that Nelson made a reasonable tactical decision not to explore an untested opinion offered by someone holding himself out as an expert. The prosecutors pointed out that Nelson consulted with other medical experts in preparation of Chauvin's case, including one who testified in state court. The jury in that case rejected Chauvin's medical defense. They also noted that the legal barriers to succeeding on a claim for ineffective assistance of counsel are very high. That they are. They have to show that basically, but for the action taken or not taken by the attorney, would have changed the result. It's possible. But the judge is allowing Chauvin's new attorneys to at least explore that. What does it hurt? Bottom line is, let the truth come out. Anyway, Chauvin is serving his 20-year federal civil rights and a 22.5-year state murder sentence concurrently at a federal prison in Texas. Obviously, I think it was originally in Arizona, where he got stabbed like 22 times. And also the United States Supreme Court last year rejected Chauvin's appeal of his state murder conviction. We'll see where that goes. I don't know if it's going to go anywhere, but the judge is at least allowing Chauvin's attorneys to explore the possibility. And if, in fact, there is a legitimate, credible argument to be had there, Chauvin would be allowed to basically withdraw his guilty plea, and they would start all over again. Next, Luigi Mangione. He has been indicted on charges that include first-degree murder in the ambush killing of United Healthcare CEO Brian Thompson earlier this month, and the DA announced the unsealing of that indictment today. The indictment on murder in the first degree in furtherance of terrorism elevates the case against Mangione in Thompson's killing outside of a Manhattan hotel on December 4th. Now, the indictment also charges Mangione with 2 counts of second-degree murder, one of which is charged as a killing of an act of terrorism, 2 counts of second-degree possession of a weapon, 4 counts of third-degree criminal possession of a weapon, 1 count of fourth-degree criminal possession of a weapon, and 1 count of second-degree criminal possession of a forged instrument. And the district attorneys there, of course, Alvin Bragg, the worst district attorney in America, says that the shooting was a brazen, targeted, and premeditated shooting during a press conference that he gave. So Mangione is also set to appear in Pennsylvania on Thursday on weapons charges, and he faces potential extradition to New York for these new murder charges. Now, Mangione has been held in Pennsylvania since he was arrested at a McDonald's on December 9th. Now, Mangione, who police say was caught with a ghost gun and several fake IDs, is facing forgery and weapons charges in Pennsylvania. Now, he was originally scheduled to appear in the Blair County court on December 23rd, but that date has been moved up to December 19th. Now, what is even a little more disturbing is that there is a poll that was released by the Emerson College, which is a private university in Boston, and they took a survey of 1,000 registered voters, and it's kind of significant because registered voters are who show up for jury duty. And anyway, 41% of the people surveyed between the ages of 18 to 29 believe that the killing of Mr. Thompson was completely acceptable. Wow. So, like I said, Thompson was gunned down on December 4th on his way to this investor conference. Of the 41% of the young voters who agreed that his death is justified, 24% of them believe the murder was somehow acceptable, and 17% believe it was completely acceptable. Now, while a large number of the young people agreed Thompson's murder was valid, 40% say it was unacceptable. Of that 40%, 33% said his death was completely unacceptable, while only 7% admitted it was somewhat unacceptable. 19% of the young Americans said they were neutral about the murder, which is code for, I have no idea what you're talking about. Men who participated in the survey between the ages of 18 and 70, 19% said Thompson's death was acceptable, with only 14% of women agreeing to that. Although each age group ranged differently, overall, voters ages 60 to 69 overwhelmingly thought his slaying was completely unacceptable, according to the survey. Now, I just bring that up, ladies and gentlemen, because, let's face it, you have to have a reason under the law. It has to be lawful to do that. Now, we'll give Mr. Mangione the presumption of innocence as it relates to the death of Mr. Thompson. They have to obviously prove that it was Mr. Mangione, not somebody who looked like him, not someone using his identity or his jacket or anything like that, but it's him, all right? He's the one that did it. That's what they're going to have to go on, or they're going to have to go on some mental health defense. But I think it's a little scary just because somebody was killed because you don't like the business that they're in, that it was somehow okay to kill them. That's wrong. That's wrong. And I know there are going to be a lot of people that are going to say, well, he deserved it. The healthcare industry is terrible and we should kill it. Really? Well, what if you work in, I don't know, any industry and somebody has a bad day and they think that you are corrupt or bad and that, you should just be targeted and killed and assassinated on a street corner in the morning? I think you would say that would just be wrong. It really would be. So if you think that it's acceptable to go kill somebody like that who running a business, whether you like it or not, hasn't violated any laws, hasn't done anything to anyone's children, I think you need to seriously think about your perspective in life. That's for sure. Hey, we'll see, Mangione's hired fancy lawyers in New York, probably billing a couple $1,000 an hour. We will see if it was in fact him. Like I said, we'll give him the presumption of innocence. The evidence is certainly not trending in his favor, but I guess if you can get those 40% of the young people who believe it was okay to kill him, you may get a little jury nullification in there. Next on the docket, the Gilgo Beach suspect has another murder charge. Lucky number 7. Accused Gilgo Beach serial killer Rex Heuermann was charged with a 7th murder today. Prosecutors revealed that all of the grisly slayings were carried out in his Massapequa Park basement. Now, the stunning new detail emerged as Heuermann was accused of killing Valerie Mack back in November of 2000. Now, the latest butchered sex worker murder linked to the 60-year-old architect is definitely getting interesting indeed. Prosecutors said that the accused killer allegedly followed the instructions he outlined in grotesque planning documents to pull off all of the murders, including using push pins and tarps inside his family home. Now, the prosecutors noted that we don't have to specifically prove where the murders happened, but they say that they have elements but they have what they need to be able to prove. The prosecutors noted, if you look at this case, if you look at the planning documents, all of that is consistent with the commission of those murders occurring at his home. Now, At the hearing, Mr. Huerman denied wrongdoing and pled not guilty. Now, according to the superseding indictment, a hair linked to the wife or daughter of Mr. Huerman was found near the left wrist of Miss Mack. Now, Huerman's daughter would have been 3 or 4 at the time of the killing, and his estranged wife has not been considered a suspect in any of these murders. Now, the father of 2 followed extreme planning measures while plotting the murders, according to the prosecutors, and noted small is good in a planning document he made ahead of the murder, according to the indictment. The planning sheet also included a slew of problems he might face, including bloodstains, fingerprints, witnesses, and DNA, according to the indictment. Now, the meticulously detailed planning documents also listed out supplies Huerman might need, including lye, acid, bags, tape, medical gloves, among other things for the murders. Now, under a section labeled Notes, Huerman allegedly wrote, "The more you do, the more clues you give." Anyway, the how-to document allegedly found hidden on Huerman's computer also included a body prep section that had a reminder to remove ID marks, i.e. tattoos, for example. Why is that significant? Well, Mack, who was a teen mom, 17 at the time, had her son's name tattooed on her left ankle, which prosecutors say explains why her foot was cut off. Now, Mack also went by the name of Melissa Taylor as working as an escort in Philadelphia when she went missing. She was last seen by her family in the area of Port Republic, New Jersey, when she was 24 years old. Now, in the year she went missing, some of her then unidentified remains were found in a wooded area in an area called Manorville. The rest of her remains were found 11 years later near Gilgo Beach, along with the remains of other female victims authorities believe were also targeted by Mr. Huerman. Mack's remains, however, were only identified by authorities in 2020. So Mr. Huerman is now accused of killing, allegedly, 7 Long Island sex workers: Mack Taylor, Megan Waterman, Melissa Bartholomew, Maureen Brainerd Barnes, Sandra Costia, and Amber Lynn Costello. Hairs found on the bodies tied to Huerman through DNA matches. Now, prosecutors also revealed that the accused killer saved news articles about the slayings, including the July 2003 report by the Post that was found in his bedroom as mementos to keep tabs on the investigation. The library of the news clippings, which were uncovered during 2 police searches of the home, also included reports from Newsday, People magazine, and New York magazine. Huerman, a New York City architect and father of 2, like I said, has pled not guilty to all the charges stemming from the murders of the 6 women whose remains were discovered near Gilgo Beach and other parts of eastern Long Island. His lawyer told reporters outside the courthouse that he planned to file a request for the charges to be separated at trial. Now, the first indictment had 4 ladies, 4 victims. Then we had 2 additional indictments. Then we've had a 7th. So yes, we will be filing a motion for a separate, especially the first 4 from the next 2 and from the 7th. The attorney also said, I don't know what else the prosecution has in store. I don't know if they're going to come back with another charge or another set of charges. He said he had no idea. Mr. Huerman will be back in court on January 15th of next year. Things are starting to pile up there for old Mr. Huerman. It's going to be a joint trial, I would anticipate, ladies and gentlemen, because the first indictment will then use the other evidence as 404B evidence. And although I hate 404B evidence, it usually means prosecution has a weak case. This is kind of what it was designed for, to show absence of mistake, to show a pattern, a motive, a scheme that one engages in. So I would anticipate a joint trial for all 7 cases. Next on the docket, past performance is indicative of future results. That's right, a convicted bank robber freed early from federal prison on a compassionate release program is headed back to prison for, well, the same crime for which he was originally sent away for. So Markham David Bond was found guilty by a federal jury in Los Angeles last week on 1 count of interference with commerce by robbery, 1 count of using a firearm during a crime of violence, and 1 count of being a felon in possession of a firearm ammunition, according to the Department of Justice. Now, Bond, who's 61 years old, robbed a Brinks courier at gunpoint at the Chase Bank parking lot near LAX in August of 2023. He had approached the driver of the armored vehicle, pointed a handgun at him, and demanded the money. The Brinks employee, fearing for his life, dropped a duffel bag filled with cash and complied with Mr. Bond's orders. Bag of money had $145,000 in cash. Bond was arrested on November 22nd, with police finding evidence linking him to the robbery after searching his residence and the getaway car he used for the heist. Now, investigators said they recovered cash from the robbery hidden inside a mini refrigerator at the home, a .40 caliber pistol containing 10 rounds of ammunition, and the shirt he was wearing when he committed the felony. The empty Brinks bag was found inside his getaway car. Now, following his arrest, it revealed that the robber had been released from custody in early 2022 on a compassionate grounds following a conviction for bank robbery and other firearm offenses back in the mid-90s. Now, the U.S. attorney had a lot to say about this and saying after being given a second chance in life, this defendant, Mr. Bond, sadly chose a path of violent crime. Now, Bond was sentenced to 46 years and 10 months in prison back in 1995 following those convictions. So yes, he truly was granted a second chance. Now, it's unclear exactly why he was granted compassionate release after serving only 26 years of that sentence. Bond was on supervised release when he robbed a Brinks employee back in 2023. And since he has such a lengthy criminal history, he is going to be considered an armed career criminal under the federal sentencing guidelines. Not to mention the fact that he was on supervised release, i.e. parole. So it looks like Mr. Bond is going to be getting a life sentence when he is sentenced on July 11th of next year. Like I said, he faces a statutory maximum of life in prison. And since his multiple decade sentence was not enough to deter him from future crime, he's going back. Now, my guess is this guy may just be a completely institutionalized individual after spending multiple decades in prison and basically figured out, wow, it's tough out here in the real world. You have to show up, you have to get a job, you have to pay bills, you got responsibilities, people expect you to do things. And if you go to prison, man, you're a big man. You used to rob banks. You had all that money. And now you're here. But you got status and you're a somebody. And I think that's maybe another reason why he wants to go back to prison. It's like a scene from Shawshank Redemption or something like that. Next, a Florida man gets the ultimate punishment. That's right. A Florida judge Monday sentenced a man who randomly murdered 5 people at a SunTrust bank to get the death penalty. Judge Angela Cowden sentenced 27-year-old Zephan Alan Xavier to 5 death sentences, with each count representing a victim in the 2019 mass shooting. The judge affirmed the jury's 9-3 decision in June to impose the death penalty. The victims were SunTrust employees Marisol Lopez, Anna Pinion-Williams, Jessica Montague, Deborah Cook, and a customer, Cynthia Lee Walston, all of Florida. Now, in Florida, a jury does not have to come to a unanimous conclusion to impose the death penalty. Now, Xavier, who was only 21 at the time, walked into this bank in Sebring, Florida, and murdered 4 employees and 1 customer on January 23rd of 2019. He entered the bank armed with a 9mm handgun and wearing body armor. Xavier fatally shot all 5 victims, then called 911 and stayed on the phone until the police arrived, and they ultimately negotiated him to surrender. Of course, they had to set up a perimeter, do all the negotiation stuff, but during the negotiations, it appeared that the government wasn't going to allow police access to the victims in the bank. Anyway, all the victims were shot execution style. Now, Xavier's defense attorney tried to argue for life, saying that he was a broken, mentally ill, and brain-damaged individual. Next on the docket, a Colorado judge gets a public censure for drinking on the job. That's right, the Colorado Supreme Court censured former Denver Juvenile Court presiding Judge Brett Woods on Monday for being intoxicated on the job and for firing an employee who first reported his problematic alcohol use 5 years ago. Now, Judge Woods was a judge on Denver's freestanding juvenile court for 17 years before stepping down in February. His departure came months after the Supreme Court suspended him pending an investigation. Although the nature of the inquiry was confidential, the Supreme Court's unsigned censure decision revealed Wood's use of alcohol on the job was a long concern. However, it went unreported after Woods retaliated against an employee who spoke up in 2019 about Woods' behavior. Woods then lied about the truthfulness of the allegations. Now, during the time frame that the Judge Wood admitted to being under the influence and the other employees had concerns, Judge Wood terminated parents' rights in over 100 cases, and if parents had come to court under the influence, they could be ordered to be tested and subject to contempt with serious implications. Not a good example to set for a judge, is it? Anyway, there's kind of a double standard and applied to the judicial officers, the length of time it took for the censure to be issued, and the continued lack of transparency of how the judge would use alcohol may have impacted the decision that he was making on all these other cases. Now, a set of disciplinary documents filed with the Supreme Court, which include Wood's signed admission to the allegations on November 15th, indicated the problem began back in 2017 after a juvenile court hired a new clerk. Within 2 years, the clerk suspected Woods was drunk on the job and smelled alcohol on him. The clerk reported concerns to their supervisors, who then passed along the allegations to Woods himself, a practice that is now prohibited. Woods told the judicial branch's human resource department he wanted that woman fired because of these false allegations. Now, of course, Judge Woods now admits that he reported employees' concerns were legitimate and that he was at the time under the influence of alcohol while at work. That's all according to the disciplinary files. Now, the clerk subsequently negotiated a separate agreement with the judicial department, and for the next 4 years, no other people formally reported concerns about the judge's alcohol impairment while at work. But then in 2023, staff finally reported their concerns about Woods' intoxication on the job again. And it is in its request that the Supreme Court suspend Woods on December 21st of 2023, the Colorado Commission of Judicial Discipline warned that Woods showed up to a send-off gathering for another judge who the governor had recently appointed to the Court of Appeals, visibly intoxicated. Woods allegedly told the other people that he was going to drive home. This reported habitual alcohol use included Judge Woods concealing alcohol in a Starbucks cup that he keeps at his desk. Judge Woods is reported to use alcohol all day, every day, with him having struggled with alcoholism for at least 14 years, wrote the commissioner's executive director at the time, a guy by the name of Christopher Gregory. In addition to direct observations of Judge Woods' alcohol use, additional witnesses have observed Judge Wood be typically disengaged in the performance of his judicial functions and oftentimes improperly delegate his decision-making authority to others. Gregory added there was an imminent risk of harm to the public safety unless the Supreme Court suspended Mr. Woods immediately. Now, the disciplinary commission later argued Woods should have known it was both illegal and unethical to fire the clerk for reporting Woods' intoxication, regardless of what the Human Resources Department told him. Woods admitted that he behaved with impropriety, engaged in retaliation, and failed to perform his duties competently and diligently. Now, he declined to seek a hearing and accepted the Supreme Court's December 9th censure. Now, at least 3 judges, including a justice on the Colorado Supreme Court, allegedly Judge Boatwright, and a Denver Juvenile Court Judge Lori Clark, were approached with general concerns about Woods' behavior in the past. Justice Boatwright did not participate in the censure decision, as it is the Supreme Court's practice. However, they did not disclose why he recused himself. I don't practice in juvenile court. I don't do that stuff. I hate it. I hate it. I hate it. I hate it. And good thing I didn't go there. Anyway, next on the docket, this day in legal history, on December 17th, 1798, the United States Senate began its first impeachment trial. A land speculator, Senator William Blount of Tennessee, was accused of plotting with England to gain control of Florida from Spain. And the Senate ultimately dismissed the charges for lack of jurisdiction, and also because, Mr. Blount, Senator Blount, who had gone back to Tennessee and refused to come back to the Senate for the trial. And on December 17th, 1959, former President Dwight D. Eisenhower declared this day as Wright Brothers Day, commemorating the anniversary of the first successful powered flight. And in 1963, President Lyndon Baines Johnson signed the Clean Air Act, which empowered federal and state agencies to research and regulate air pollution, laying the foundation for future environmental legislation. And finally, our dumb criminal of the day. These guys just couldn't do anything right. So 2 suspects are in custody after a burglary attempt ended with a failed escape. About 8 a.m. on December 10th, a homeowner called the Jefferson County Sheriff's Office, which is in Washington State, to report an active burglary. The homeowner told deputies that 2 people, a man and a woman, were dressed in black, had broken into a storage container and took about $11,000 worth of gold and jewelry. The owner spotted the suspect leaving an SUV, and the license plates were covered. However, the owner of the stolen items tried to stop the burglars by throwing firewood at the SUV, ultimately shattering one of the windows. Now, as deputies answered the call, deputies found the SUV rolled over after a crash down the road. And the SUV was on its roof, but the suspects had run away on foot. Well, then the Jefferson County sheriff used a drone to look for the suspects after learning that the suspects stole a small rowboat to then escape. The rowboat started taking on water and began to sink, forcing the suspects to swim back to land and swim right into the hands of deputies waiting for them on shore. Now, the suspects were taken for medical evaluation and then booked into the Jefferson County Jail. Dumb, dumb, dumb. They did everything incorrectly. Thank goodness justice will prevail. All right, that's all we have for today. Thanks for watching. We'll see you tonight, 6 p.m. Mountain Time for our Tuesday Night Live. And remember, the Constitution matters.